Does the Sexual Assault Reform Act apply to youthful offenders? To find out, you have to read People versus the Superintendent of Livingston Correctional Facility. But it's 10 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less, or about that if I can. This is the episode on the case of People versus Superintendent of Livingston Correctional Facility, published by the New York Court of Appeals on June 15th of 2023. The citation for this case is 2023 New York Slip Opinion 03298. I'll include a link to that decision in the description. And the issue in this case is, does the 1,000-foot rule, the rule that a sex offender cannot live within 1,000 feet of a school ground that's called SARA, the Sexual Assault Reform Act, does that apply to youthful offenders as it would apply to everybody else? To understand what's going on with this case, you have to understand three areas of law that are interesting, and they have an interesting interplay. The first is what a sentence is. There's a section of the CPL, the Criminal Procedure Law, CPL 1.20, which defines the terms that are used in the sections of law about criminal law. And the definition of sentence is found in 1.20, and it means the imposition and entry of sentence upon a conviction. So whenever the term sentence is used in the CPL, they mean the imposition and entry of a sentence upon a conviction. That's the definition of it. The second thing you have to understand is what a youthful offender adjudication is. Under Article 720, the legislature of New York passed a series of rules that basically recognize that people who are under 19 but over 16 may commit crimes, but not really. They commit crimes for reasons because their brain's not fully developed. It's sort of like youthful indiscretions. They still may be crimes and criminal actions, but the legislature identified that some people like this age are entitled to have what's called youthful offender adjudication. And it takes the place of a conviction. There's no conviction when you're a youthful offender. You get a youthful offender adjudication, which is called the youthful offender sentence. It replaces the conviction with a YO adjudication. And the whole point is to give a clean slate. So, if you do something stupid when you're 16, if you spray paint a wall, that doesn't follow you for the rest of your life. And then you can't get a job. You can't work as a police officer. You can't get certain licenses. It gives you sort of a clean slate. And the third thing to understand is there's something called the Sexual Assault Reform Act. And this was passed a few years after SORA, which is the Sex Offender Registration Act. And the concept by the legislature was that we have to protect children from sex offenders, from the risk of reoffense. So SARA, the Sexual Assault Reform Act, created a rule that if you're convicted of a sex offense, you can't live within 1,000 feet of a school ground, which means schools, parks that are attached to schools, daycare centers, all kinds of places like that. And for New York City, that becomes a problem because it's hard to find compliant housing in New York City that complies with SARA, because 1,000 feet is a lot when you think about how many different school grounds there are in New York City. And what DOCS has decided to do, what the Department of Corrections has decided to do, is if a person cannot find compliant housing, they won't let them go. That's how DOCS deals with the SARA requirement. Okay. So what are the facts here? The facts are that the petitioner in this case was 18 years old. So he was under 19. He's 18 years old, and he committed he may have committed a completed rape, but he pled guilty to an attempted rape of a 13-year-old victim, which is a SORA, it's a sex offense case, a SORA eligible crime. But instead of getting a conviction because he was over 16 and under 19, it was YO eligible. It was eligible to have a youthful offender adjudication, which he got. He was sentenced to 10 years probation, but because he violated the terms of his probation, he was incarcerated, okay? Resentenced to an indeterminate period of incarceration. But because it's SARA, it's one of those SARA offenses he was convicted of, or he was found guilty of, he had to find compliant housing before they would let him out of jail, but he couldn't. So they left him in jail for an extra 9 months or so because they won't release him until and unless he finds compliant housing. So he then sued. That's this case. He said, wait a second. I'm being illegally detained. And the argument goes like this. SARA only applies to a person serving a sentence. A sentence is defined under CPL 1.20 as an imposition of a sentence upon a conviction. As a youthful offender, I don't have a conviction. Therefore, I don't have a sentence. And because I don't have a sentence, you can't apply the SARA rules to require me to find housing that's beyond or 1,000 feet or more from school grounds. The trial court denied that application, but the appellate division agreed with it. And it goes to the Court of Appeals. And at the Court of Appeals, they had to address whether SARA applies to youthful offenders as well as adult convictions. And they say, this is the holding, is that it does apply. It does not matter that there's not a formal conviction, that in fact, instead of there being a conviction, there's a youthful offender sentence, which takes the place of a conviction. They say for the purposes of SARA, the term sentence does include youthful offender sentence or a YO adjudication. So that's the holding of this case, People versus Superintendent of Livingston Correctional, that SARA applies to regular convictions as well as to youthful offenders. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.